So that's
Yeah, it is. Right. Okay, good evening, everyone, and welcome to our Thursday night seminar. Tonight, we are joined by Mohammed Haq with the latest in his changes to construction contracts, the valuation and other implications. As always, if you would like to ask Mo a question on this topic, please feel free to use the Q&A or the chat facility in your bottom toolbar. Alternatively, if there's something you'd like to ask him but you don't wish to do so in an open forum, please feel free to email him. You can see his email details there on the screen, mohammed.hack@fletcherday.co.uk, and he will be delighted to assist as he can. Okay, Mohammed, without any further ado, let's hand over to you, please.
thanks, Julie, and thanks for everybody who's joining me this evening with my attempt to go through, which I felt over the last 25 odd years to be very important in construction contract for various reasons, of course, which might cause an employer to spend more money or even less, to be honest. And so the contractor may be entitled to get some extra money, or may not, or may need to perform but don't get anything out of it. So all sorts of possibilities come in. And just as usual, I will remind you that under common law, once a contract is entered into, it can be performed, it can be frustrated, it can be breached, or it can be varied. So common law always provided a mechanism to enter into another contract. And as English law standing today, it changes, that's why I'm saying standing today. If you have entered into a contract by deed, from that common law perspective, it can only be varied, and that's written in most of the model forms and bespoke forms as well, via a deed. If you have entered into a contract in writing, it's most likely that you will only be allowed to vary it in writing, and so on and so forth. However, given the normal course of a construction contract, given that many things changes over the course of time in any construction contract, it's not like a fast food selling or selling a goods or a product which has just been sold and then the seller goes away and the buyer gets everything. It's not like that. A construction contract continues for a period of time, and during that period, either party may want to change something, or even there are changes in law which requires to change certain terms. So changes are obvious. So what is generally done in construction contracts, we have always a set of clauses which tells us that either party can change, and they prescribe a procedure, and they if a change is formally done through following the procedure prescribed by the contract, then evaluation of that is required. And the overall aim of this talk is to talk about other implications, such as not only the price adjustment, the time-related impact of any change as well, but that will come towards the end, the other implications. But first thing first, it needs to be a change. And just to recap, we have been discussing primarily NEC and JCT, and I have started with JCT after discussing the common elements. Now we are in a specific situation, JCT, And in the last episode of these webinar series, what I've done was setting up the issues under JCT. What changes are possible, what are the different types of contract modules we have under JCT, what are the specific requirements, and blah, blah. Today, I will be focusing on primarily what is or is not classified as a change under the JCT suite of different sort, and I will be focusing on primarily the standard building contract with or without quantity. And of course, I will also be touching on the design and build. Okay. Now, coming to the point of how is a change defined? A change is actually defined in clause 3.10 or 3.14 of the standard building contracts with or without quantity, which is more or less in the line of the alteration or modification of the design or the quantity or the quality of the works. So this is a standard building contract, meaning it's a traditional procurement. Other than the contractor's design portion, the contractor doesn't have a responsibility to design anything. So any design as agreed on the day of the contract, if changed, that's a change. And if the design is not changed, but a quality is changed of the activity, or, for example, of the things that are used very common in the kitchen. You agree something regarding the white goods, and then at the real time, you may change your mind. At bathrooms, quite common that you change the quality of the tiles and the floorings. Floorings is something like it's been changed all the time. Then the decoration wise, painting specifications, they change because it comes towards the end and the employers make their mind up and then they change, and there might be a cost implication there. So all sorts of different types of, not a design change as such, but just maybe a quality change of some goods to be used, or some quantity change in the goods to be used as well, because sometimes what happens, different types of doors and sunroofing, windows are used, and then at a later date, the employer might think, okay, no, I'm going to go for this type of door for all the internal doors, or the external door, not to be one, will be two. So that sort of thing, the changes made simple about the design, the quantity, the quality. However, whether you are a contractor or an employer, regardless, or acting for the employer, because the employer it's not. I mean, I would suggest, if you're a prudent employer, to follow this anyway. That to create a tracker, well, because I've got QSing background, I would say in an Excel spreadsheet where you will have a templated document in which, in different tabs, you'll include, let's say in the design, you must consult the drawing issue register and how it developed, because each time a new drawing is issued, there's a potential of a change, because if you have changed something, but not necessarily. If you're very new in this, why that's not necessarily the case, I will explain in an easy way, is that that RIBA, the Royal Institute of British Architects I'm referring to, has stages of plans. And historically, if you're in England and Wales, the schemes are tendered around stage 3. And if the architect or other designers of the employer is to carry on, if it's a standard building contract, then they will obviously issue new sets of construction designs. Okay. either through specialized professionals or through their own in-house, whatever. There will be, And so the drawings, just because there's a new drawing or more clarification on the spec, it doesn't mean that there is a change in design or quality, because it could be that it's just explained in a detailed manner. Okay, so for example, in a planning drawing, the first fixes are normally given, the second and third fixes are not, and automatically when it comes, they give you the construction drawings. They detail the first and the second fix. Of course, some kind of spec should be given. Let's say we're talking about a bathroom or a toilet, but mind you, this might happen that the first construction design, let's say of a bathroom or a kitchen, for example, is given to you at the construction stage, and it doesn't change any of the points of electricals or mechanicals. For example, the piping work was looking same to come up to the sink, or the washing basin, or the toilet, or the shower. Okay, it's all fine showing that. And then if from the planning design, if in the construction design the points being changed, that has an implication, because you have to then, if you have already done it, you the contractor, I mean, if your contractor has already done that, then they'll have to redo it, and that's a change. So before, you just go on site, the employer, and think, oh, you know what, the shower should be not in this corner, should be that corner. Okay, you should understand that if you want that, that has an implication, because it could be that the first fix has already been laid, and the costing may be different if it has to be done now differently. Okay, same comes about the number of switch box, number of lights, number of dimming provision, and whatnot. So every time a drawing is issued, or a new explanation is added, everyone should look at if it changes anything from what was earlier given. It not all the changes give you or new drawings will make a change in the design of the quantity, the quality, but it could very well be the case. Now, how would you know this? Normally, and especially the smaller contractors, they fail to keep track of, or owners of houses who are doing extension projects and things like that, they fail to keep a track of what they have earlier wanted. That's a major problem, because when the final account comes, the contractor starts claiming different things, that no, this was that, and I have done it differently. But then a fight starts all the time. Rather, to avoid it, I would say, if you have a tracker in your hand, that these are the drawings been given, this is what you understand of the drawings, these are the specification documents given, this is what you understand the specification to be, this is the quantity that's required, and this is the quality that's required, this is the type of workmanship expected. You exactly know if on any request from the employer or the architect, when the employer, the architect making it, I'm not saying it has to be maintained only by the contractor or the architect or contract administrator or the employer. I would say know your contract better and keep a simple list, and including who's doing what and whose role is to do something and not to do something, So who's the quality manager in this? You're taking back works, you're authorizing payment, you're a contract administrator, an architect. What's your basis? Try to know your role, your limitations. Are you in a position to certify that the work is done properly, or you are just relying on the defect liability period, that if any problem comes in, you will just resort, and if not, then you'll go away. Please, please do not work like this in a reckless manner. Every one of you should know what your role is. And I would refer you to, if you're an architect or contract administrator, to the RIBA site. They have a construction phase work plan. They have a booklet of about 148 pages, completely free, and also an Excel spreadsheet, which gives you like every stage 0, these are the possible people involved, these are the tabs where you go there and name the number of people. Well, I mean, BIM these days are doing all these things very well, and other softwares are getting into the market. But, you know, you don't have to have such a luxury. I don't have BIM, I don't know it, I don't want to spend time on a software. But you can always create an Excel spreadsheet following the template RIBA is issuing for free. Just go to that work plan. And what will happen if you go there, if you know in what stage you are, if you know your what drawings and what specifications, what reports are part of your design, and what metrics and what requirements you have set at the time of first design you have issued, then if you just go within the range and start giving more and more clarification, it won't be treated as a change. Otherwise, it might be treated as a change. And of course, if you change your quality, you will know. It's a balance. Some people think that, okay, I will not be very elaborate at the time of making the contract. I will go alone and I will spend some more money if I change the qualities, and that is if that is the explanation. But my personal choice is make it as detailed as possible at the time of entering into the contract, so that you only can go in and just 3 different columns. Okay, this is the design thing, summary page, goes to the tab. These are the things I had for the design. Now the drawings I'm issuing, or a spec I'm issuing, or a report I'm issuing is changing it. So there is a change, otherwise not. Now, also, clause 5 sets up that a change is a change if the employer imposes any additional obligations or restrictions, or the addition to or alteration or omissions to the existing obligations primarily. And please remember, it's like a concept which works in all discipline of law, which is called indispensable necessary. So if the express clauses says that you're obliged to do X, if Y is a must to be able to perform X, then Y is also by implication included into the obligation. And if the employer asks the contractor to do that, which is an indispensable necessary, then he cannot say that this is a change. A change must be something which was not included as part of the bargain in the original contract. So how would you be able to find it out? Go to the contract documents. What are the contract documents? The pricing document, of course, primarily important, and we'll see today that there are different things as per the type of contract. And then there is this specification and the drawings and the designs and the conditions. You know, why the conditions are important? Because sometimes the employer or the engineer or the contractor has the right to change things for which of no effect so far as valuation is concerned. I'll be dealing with that more when I'll be dealing with valuations. But mind you, at this point, very important to remember, sorry, very important to remember that you meaning the contractor, is only entitled to call a change and evaluation, or get or looking forward to for other implications, provided the employer has added an obligation onto you. So in most cases, the contractor is responsible to choose the method in which he does. So if you change your method, then you're, and the architect or the employer accepts it, it's not a change, because method is default position wise your responsibility. And as we know, the QSs know it and should know it very well, that under each item of works, you have many alternative methods available to perform it. And of course, there are financial implications to each method. Okay, there are quality implications as well. I give you an example. I was involved in a very large earthwork contract a few years ago at Thames Estuary. It's called DP World Port or something like that. Dubai Port, they used to call it, I remember. In Dubai Port, I was working for the earthwork contractor who was given the work by Murphy's, the leading contractor. And the dispute was a change in method of cutting and filling a particular part of the site. Now, eventually I won it because the simple fact that the specification said that the reports you need to, the employer's specification said that the report the contractor needs to provide is to be accurate up to a certain degree. So the contractor chose a particular method of cutting and a particular method of filling as well. Now, later on, the spec was changed, and the contractor said, we need to change the method because you are giving us a narrower range of tolerance or, or accuracy. So we need to go to a robotic grader to find out. And to hire a robotic grader is an expensive thing, per shift. It charges a lot of money. And the employer said, okay, fair enough, you carry on. And after they have completed it, they say, look, the method was your choice, you have done it. So we are not going to give you a single penny extra because why did you propose that a new method is needed? You're an experienced contractor and you should have known it right from the day one. Now, advantage for us was that there was a formal instruction from the architect, or it was not an architect, an engineer, that there was a change in the specification itself. They were looking for a different type of thing than what was agreed upon, at the time of the contract. And that narrow thing saved them. Otherwise, if you change it, oh no, it seems to be better, at the site level, you decide, the contractor, that this is better performance, so we will not do this, that. Go back to the architect or contract administration and say that we are changing it because it's good, and the architect said, Pally, fantastic, go on and do it. Later on, you cannot just turn on and say that, look, you asked me to change it, I've changed it, now pay me the extra money. No, because the method is contractor's choice, and you have chosen to change your method. If that becomes more expensive, that's your headache. Now, so also to bear in mind that something different is not additional. Please do remember it. If you're a contractor, do remember this, that something different is not normally additional. There is a case which is widely criticized. So do not be sort of excited by by looking at that case that, wow, there is a case which says that. In a minute, give you the name of the case. The case name is Simplex Concrete Piles v. St. Pancras MBC, is 14 BLR 80, where the contractor failed in its original attempt and to do some kind of foundation piling, and it changed the method, and it offered a new way that involved extra cost, but the architect accepted it, and it was decided by the court later on that although this was not an addition because the architect accepted it, this was a change. Highly criticized case because normally the established rule is, it goes in favor of the employer, that if and until you can show that this was an addition to your obligation, it's not a change. But as I said, this is, a drowning man catches at a straw. If somebody comes to you who has done it already and the architect has somehow accepted it without adding a note, unconditionally accepted that, okay, a change, this difference into an instruction that I accept this difference, there is a chance. Now, if you're an employer, an architect of the employer, of course, don't take like stupid decision by just ticking all the time the box, but you can, in your standard instructions, put a box in that are change without evaluation. Okay, so if, regardless whether it's called a change or not, if you take that and tick that box, in that case, unless you have ticked the box unreasonably, you'll have a chance to protect your position. Okay. Conversely, if you're a contractor, you add up whenever you are taking such instruction, you send back a CVI, contractor's variation instruction, that this change or this is a change, consensual, and we are entitled to a different valuation. If the employer doesn't reply, it's under the deeming provision, you get a chance. So still, it's not a very good ploy, I would say. Better be safe in the first place. Do not go and change your own method. But sometimes what happens, if the architect or engineer of the contract has the right to dictate the method, in that case, as long as it's a method acceptable to do the work, if it's more expensive, that's your headache. How can you avoid this? As told you, go to the contract documents. And in your pricing document, if you can set this limitation up, that your price is for this and this method only, then in your contractor's proposal, you have clarified it. And if then it's changed, you got a better position. So remember that, keep that in your mind when you're pricing. Well, I've been discussing it, the imposition by the employer of any additional obligations. Of course, a similar rule applies for restrictions. And I'll come to in a minute, what is a restriction? The restriction is most likely into the site. It's underlying into any construction contract. Well, of course, unless expressly this has been excluded, that a free flow chance to be given to the contractor to perform or its subcontractors to perform. Now, if you have a particular, because there are sometimes difficult sites, and it's always good that you should if you are the contractor or the subcontractor, visit the site and take notes of the special difficulties. So it could be height related, and it could be that scaffoldings are not available due to narrow passages, and it could be some other problems of lights. It could be entry issues. It could be that I've been doing a claim of late in an airport where the rule is every time you get in and come out from the site is something called isolation needs to be done. You know, there are security issues. Each of them could be troublesome for you. Same as if you are going or working in railway, in Network Rail, in London Underground stations, you know, possession is a big issue because trains are coming and going even during the off hours, and you have disruptions. Now, if that has been described, and then it's an employer's choice to impose it or not, and then that restriction is imposed, you're not going to get anything extra unless the contract says so. So read your contract documents, the tender documents as to the restrictions, do a visit and try to find out, because you are supposedly a specialized contractor. So by looking at the site, you should be able to know your problems. If you are not yourself confident, take your specialized subcontractor with you and look at the site and ask for them. A lot of time the contractors just buy and sell, meaning they buy the specialized service from the subcontractors and specialized trades and then sell it by adding a margin. There's nothing wrong in it, but you got to put the subcontractor into risk of this sort of things. That what will happen if there is a lot of risks and restrictions coming up during the performance? What have you allowed for in your price? How many hours, and what sort of restrictions you're expecting? What sort of restrictions you have experienced in your earlier jobs? In your pre-contract meetings and your pricing documents with your contractor and the subcontractor, you must have a section like that, and then you refer that to or incorporate that in your contract so that you stand a better chance, okay, at every stage. It's an issue of clarity for everybody, and whoever is clear will win the race eventually. And so I've discussed addition or alteration, of course, in changing specs and all. Then omission. What about omitting some word? Now, obviously, a common law again, no one can omit things once a contract is entered into. That's a breach. Okay, you can't. As simple as that. However, standard building contracts like JCT allows omissions. Okay, expressly allows that the architect, the contract administrator on behalf of the employer is entitled to omit works. Now, first thing to understand is that no employer under a JCT contract is ever required to add anything. It's a privilege for them. So for instance, if the employer decides that he will do an addition to the contract through a third party, the contractor doesn't have any right to claim that, no, because I have the contract, I'll have the right to get that variation as well, or addition to my obligation as well. There's no such right for the contractor, unless, of course, there isn't any English law case. The cases are mostly from Australia, but that's fair enough. I mean, it's the same. It's a logical thing that you cannot claim that the employer is only allowed to give you additions or variations unless you have expressly limited the hands of the employer that any variation of the contract items must be given to the contractor. Okay, so if you want that, then there's no harm to propose something like that, and that's not going to be treated as an omission if the employer fails to add, unless this sentence is there, as I've just stated, that the sole right to have extra works on the items discussed or on the matters which comes directly or indirectly within the scope of this contract, only this contractor has the first priority, unless such a clause is there. If the contractor, the architect or the employer decides not to give you a variation, you can't do anything. Okay, but if it's an item which has been agreed to be yours, and for one reason or the other, the employer says, I don't want this from you, well, you have the right to go to anybody, right? Just because it's cheaper, the idea is, yes, he can go, but he'll have to pay you the loss of profit. He won't pay you the full value of the work, but he will be required to pay you the loss of profit. So if an item of work is for the contractor to do, and if the employer decides that he wants to get it done by someone else, that's fine. All he needs to do is to pay the loss of profit to the contractor. It's not a defense in mouth of the employer to say that I have the right to withdraw, so in my sole discretion I've withdrawn. I'm not going to pay you anything for this. No, evaluation is needed for every change. An omission is a change, and that valuation is the profit. Now, don't ask me at this episode what that profit's going to be. It's a quantum issue and evaluation issue I want to deal with next time. But remember this. The last thing on this slide for us to remember is that provisional sums. You know, in JCT, we have these provisional sums. Provisional sums are of two types. One is a provisional sum where you couldn't, you meaning the employer, couldn't provide sufficient information for the contractor to be able to price it. Maybe the specs were not ready, maybe they were consulting or waiting some more reports or something. So if that's the situation on the day of entering into the contract, the parties simply add a provisional sum, okay? And at the material time when that's possible to be priced, it's handed over. So there's a design change or a quality change or a quantity change, and new quotation has been given. And if it's agreed, how it's valued, we'll see differently, but that's a change, okay? There could be that price-wise, it was all definite, but employer couldn't make up his mind whether he wants that or not. It normally happens for, let's say, for a cinema room, for a swimming pool, or a heating system, or a sauna or something, you know. Price was probably achievable and was discussed, but the owner was not sure that whether to add it or not. What's the difference? If it's price-wise okay, it was priceable and agreed that the same price will be used provided the employer issues the instruction, then all the prelims should have been added into the contract and there won't be any application for extension of time. If it's an undefined provisional sum, and if the employer wants it to be added during the life of the contract, then the contractor must consider the time impact and the prelim impact as well. I will get on to this next discussion again. Now, well, just some examples that the obligations and restrictions I've referred to above: access to the site, specific part of the site, limitation on working space or working hours. Well, where do we find the working hours in a JCT contract? Nowhere, actually. Nowhere within the JCT contract is specified what's gonna be the exact hours and days you're entitled to. It only says the date of the award, you know, date of commencement at the site, completion stage-wise at the site if stage completion or practical completion date, and then added to it a chunk of time for defect liability period. I request, if you're the employer or the architect, all my architect friends, they say, that's for the contractor. Why do I bother? You should bother because it's in everyone's interest that the project is to be finished within time. So when somebody is entering into a contract, please, please, please have a clear list of works items. Ask the contractor for a clear program, although I know that JCT only requires the master program after the completion of the contract, but analyze it before you enter into, and ask the contractor to demonstrate to you, if you're the employer or the architect, that for the activity, the amount of time assigned per the method they're talking about is achievable. Now, if not, then you have a fundamental flaw. Jones, how many weeks or how many months? You're, I think it's 9 months. Oh no, don't kill me. Do it in 6 months. It's only a small refurbishment. It's not an Indian fish market. Go to item-wise breakdown, assign each item a specific timeline. If you are doing like plastering, then curing time. If you are doing foundation, then starting to the end and how many days you got to wait before it's allowed to take the load on, that sort of thing. Okay. And if you are cutting and digging and putting the spalls on somewhere, and then there's a bulkage factor, what will happen after you finish and then you bring it back, and all these issues, how time affects. Please consider that realistically. And of course, critical path is another thing you have to take into consideration. If there is a change in that, there you go. You will know who's at fault and why either an extra time will be required or a liquidated damages will be imposed. If the contractor failed to provide you with right machinery and the right type of information at the outset, then his headache. Why did he made a mistake? But unless you have the baseline exercise done, every party should be involved in that and do it. Same is carrying out of work in a specified order. Trital in his book, I first come across in his book of contract. Let me see if I have a copy of this. Trital's Law of Contract is the name of the book, where he has pointed it out, that order of performance. Okay, if you want a particular sequence of the works to be done, if you're the employer or the contractor, then please spell it out in the contract, somewhere within the contract document, that my price is based on works in this order. If you change it, I have an issue. I will treat it as a change, and any valuation implication is on your risk. If you fail to do that, then the other side might take a chance. Now, as I said, I'll be concentrating on standard building contracts with or without quantity. What is the significance? If it's with quantities, meaning you have a bill of quantity, and I prefer that because if you have a bill of quantity, you have got a degree of certainty. It's a lump sum contract, and you have a degree of certainty, and the default position is the liability or the responsibility of the bill of quantity is for the employer. Well, it's quite widely amended to say that the bill of quantity is only adopted for understanding the pricing and for variation purposes to be used. All the responsibility of the mistakes in the quantities is on this contractor's shoulder. My personal preference is create a bill of quantity jointly. So even if the employer started a bill of quantity, ask before tendering from the contractors, as many you have sent, to put an input there, do their own taking off. And if you follow the NRM or SMM, well, now the NRM, of course, no more SMM possible, or SESM, or the highway bill, whichever sector you are in, it's highly unlikely that if you do it jointly, you'll have problem. You might say it's not practically possible. I would say it's pretty much practically possible. Whenever I have advised employers, I say, bring your all intending bidders within the room and let's discuss it. So you will have less chance of a mistake, and then share this problem with the contractor. Okay, so that if there is a genuine mistake in the odd case, you have a solution. Okay, if it is without quantity, in that case, the contractor is actually pricing the drawings and the specifications, and if he fails to take it off properly, that's his headache. The best chance the contractor stands is doing it through the subcontractors, specialized subcontractors, and passing the risk on to them. Okay. Changing the site condition, for example, is not actually something which the contractor can claim as a change. What I mean by that, you have a subsurface report, and the default position is regardless of that. If you go in and see something different, then that's contractor's headache. Unless you make it specific within the articles and the agreements and the conditions that I'm only taking this or pricing this because based on this report. But the problem is most of the time the report itself will say that you can't rely on this. So it's a very difficult situation, but that's what it is. Finally, for CDP or for design and build, a change is a change, not in the change of a bill of quantity or specification. It's a change, of course, in the specification, if the specification is part of the employer's requirement, the change has to be a change of the employer's requirement. That brings us to the next or the last point tonight, the changes under the JCT contract, the definition, the design and build. And the design and build, it's defined as the alteration and modification, and that applies for the contracted design portion in other contracts as well. The alteration or modification of the design, quantity or quality of the works via a change of the employer's requirements. The imposition by the employer of any additional obligations or restrictions, or the addition to or alteration or omission of any obligations or restrictions, of course, as defined in the employer's requirement. These obligations or restrictions are the same as we have discussed earlier. Now, change formalities. I've touched upon this earlier, but I will do it once more. The changes are made through instructions by the architect to the contract administrator or employer's agent. And remember, a very, very vital point, that the change the architect or the contract administrator or the employer's agent is issuing or claiming to make, you must first be able to establish that he has the authority to do so from the text of your contract. I just give you a simile, like the employer's agent do not have a right to agree a quotation for a variation under a design and build contract, unless it's specifically in writing or been given by the employer. So there is case law on that, that if the architect was not permitted to make a change, and if he does so, the employer is not responsible for that. So please read through your contract very seriously to find out the scope of the architect, the contract administrator's ability to change. Please also remember that if you are the contractor, that you have been given the right to refuse, however, you cannot unreasonably do so. So you at least have some protection. You don't need to sort of accept a change in your obligation, but you shouldn't be unreasonable to do so. I was just deciding an adjudication last week, an interesting clause in a bespoke contract which said employer's architect in its absolute discretion may direct the contractors to do anything it wants to in addition to the existing obligations, and they are bound to perform it without questioning the authority of the architect. Interestingly, the architect or contract administrator given an instruction, 3 instructions of variations, the contractor didn't oblige. And then the 4th time, the architect has said, unless you come in by such and such date, or please, it said, please do come by such and such date to perform the earlier variations and this instruction as well. And they've given 5 days time slot for the contractor to come and do those. And then they've given, then the contract said that if the contractor failed to perform, then the employer has 5 days to decide whether to sack the contractor or terminate the contractor or not. Now, employer, without waiting for the 5 days, issued a notification of termination, and that termination eventually I decided to be wrong. So because of the contract itself. So be careful not to fall into the tricks of it, because default position in JCT, it was a JCT and they amended it, that no, you don't have an option to do, but then they have added for the employer a requirement that they'll have to wait for 5 days before they issue a termination notice. And the employer, after issuing the invitation to come, they have, without waiting for 5 days, they issued the termination notice, and that's why it has become wrongful. So, as I discussed earlier, the change instructions could very well be saying that there's no entitlement. Changes include instruction to expend provisional sums. I've discussed it as well. A change may result if the contractor finds a discrepancy or divergence in the employer's requirement document. He must notify of this. The contractor may raise a CVI for any changes the employer did not make via instruction, but do not leave it for an informal variation or change. And changes in statute after the base date is a change. What is the most common example? All the statutory undertaking works. You get the permission from the statutory undertakings normally after the contract is entered into, and the base date is always normally before the contract was entered into. So the orders from the statutory undertaking is a change in law, and that's a change. And that's why you will see normally it's always a provisional sum. And that's all from me today. And if you have any questions.
Oh, sorry there, Mohammed. I was having a few issues technically. That was great. Thank you very much. If anyone does have any questions, now is the time to ask using the Q&A panel, the Q&A tool or the chat tool in your panel at the bottom there. Otherwise, as we said before, if you'd like to ask something, ask Mohammed something directly, it's mohammed.hack@fletcherday.co.uk. That's it for this week. We are back next week, where we are joined by Mohammed again for the problem with subcontracting is, and that's on Wednesday the 10th it's actually at 8 AM, not 6 PM. That's an error there. And then we have construction roundup on Thursday the 11th of November at 6 PM. One of the things on the agenda for that will be the impact on construction from topics discussed at COP26. So that should be an interesting debate there. If you would like to book a place on any of these, or on either of those, or any of the ones you see on screen, please email us seminars@fletcherday.co.uk. It just remains for me to say thank you again to Mohammed for his time this evening and his expertise and sharing that with us. And thank you to everyone who's attended. We look forward to seeing you all again very soon. Thank you and good night.
Thank you, Julie, and thanks everyone who's attended.